SJC-13750, Commonwealth versus Scott A. McCaffrey.
Okay, attorney and judge, whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Emma Quinn Judge, and I represent the defendant, Scott McCaffrey. This case is about two fundamental principles of fairness: the right to indictment by a grand jury and the requirement that a jury get proper instructions. First, we know the defendant must be convicted and indicted for the same charges. Here, the defendant was indicted for aggravated rape under 23A small b, but convicted under 23A small a. So he was indicted under one section of the statute, convicted under another. He was charged under one theory of aggravated rape, convicted under another. And the Commonwealth has identified not one case that allows either of those types of changes, let alone both. The case law draws a clear line between changes of substance and changes of form, and indictments may never be substantively amended, which is what happened here. An indictment of form is one that is not essential to the description of the crime charged, and that comes from Snow and Knight. And that language, it's worth noting, is not limited to the word elements. It says not essential to the description of the crime charged.
You don't have time, the timing of things has not been considered substantive, right?
Right. Date has not been considered substantive.
So given the date relates to the age here, does that matter? Or it's a question. It's not a rhetorical one. I just don't know.
No, and it's a question I've thought about because it is obvious that there's a relationship between date and age. But the issue here is that the statute, we know that the Commonwealth generally doesn't have to prove date, right? There's a statute that says they don't have to prove date, and there are cases consistently saying date is not an element of the offense. The offense here, however, is defined in terms of age and in terms of age difference. And so where it is essential to the definition of the offense, at that point, any change to it would become a change of substance. I agree that there's an analytical similarity between date and age, but here the offense clearly requires that you find the age in order to convict. So, changes of form have been those where you don't change something that the Commonwealth has to establish at trial. There are all those date cases. There are the name change cases. And then there's this category of cases where you prune indictments, where you take out surplus, or you have alternate theories and you narrow down to one theory. Or you have the Miranda case where you didn't change the elements, but there were two indictments, and one was the sentencing enhancement that was charged separately, and you combined those, but no elements changed in that process, and those are all changes of form. But the cases are consistent on the other side that it's a change of substance when you change the statutory subsection, whether, by the way, it gets better or worse for the defendant because we don't consider prejudice, when you change the offense within a single statute, or when you change theories.
You mentioned alternate theories. I think that's their argument, that these are alternate theories of proving this offense, correct? Aggravated rape of a child. That's
right, and there are also cases that say you can't change the theories of the same offense. You have this court's decision in Mayotte and the appeals court decision in Garcia. In Mayotte, you were dealing with the reckless endangerment statute, and there are three different ways to prove that. The statute lays them out separated by the word or. It doesn't use subparts, but it's all in one statute. And when there was a change there, when the defendant was indicted for one but convicted for the other, that was a change of substance. And you have the same in Garcia. In Garcia, you are actually dealing with the same statute that you have here. The defendant was indicted under 23A small a for natural sexual intercourse, but then was tried on a theory of unnatural sexual intercourse. So again, the subsection didn't change, but the theory of the case changed. So no matter which one of those things you do, whether you view it as changing the subsection, changing the theory of the case law has drawn this clear and consistent line between changes of substance and changes of form.
Do any of those cases, and this is a real question, not that all of my questions are not real, but you obviously are very familiar with the case law. Do any of those cases involve evidence for a crime that the grand jury did not have. Do you see what I'm saying? So here, the grand jury was presented with evidence that the child was under 12, but they indicted for the crime where the child is over 12 and less than 16. So there was a failure of proof of any of that at the grand jury stage. So there was something wrong with the indictment at the get-go. Do any of the cases that you're referring to have that failure in the grand jury minutes and evidence?
I'm not sure if I'm answering the exact question you're asking, but let me know if I'm not, I guess is what I'll say. In the Mayotte case, all the evidence, as far as I can tell, based on the Commonwealth's argument, because the Commonwealth's argument in the Mayotte case was the grand jury heard this evidence, so it doesn't matter that there was a change. So in that case, it seems like all the evidence for either theory was presented to the grand jury. And in the Garcia case—
But that's a different, so wait, in Mayotte, there was evidence for both theories?
presented to the grand jury. I mean, that was the
But
Commonwealth.
here, there's no evidence for B.
Correct.
Okay. So is there a case like that?
I don't believe there is a case like that.
Yeah, so that's what has been bothering me about this case for me, because your case law is about substance versus form, where the grand jury actually could have indicted on, the charged crime. But here, the grand jury made a mistake because there was no evidence that the child was 12 to 16.
Right, and I think the concern with relying on the idea that it's a mistake is that in a lot of these cases, you could come back later and say that someone made a mistake.
But that's why I asked you about the particular case law that whether there's no evidence before the grand jury that she was 12 to 16.
Well, so let me talk about two cases, actually. So the Souza case from the appeals court, the indictment is fundamentally garbled because there are two firearms offenses, and the indictment charges one offense and then says to wit some type of weapon that's not covered, and I'm just trying to find the details of that. It's a charge with carrying a dangerous weapon, to wit a handgun, but the section of the statute doesn't talk about handguns, right? So there's clearly a mistake there. They then go back and fix it to A, which does cover handguns, and amend it to knowingly possessing a firearm. So that's one where there's this sort of garbled indictment that kind of tries to charge both things, and they realize they've got it wrong. In McGilvery, they charged the wrong drugs. I'm not sure, however, what the record before the grand jury was, so I don't want to overstate my point there. I do think the Souza case comes closest perhaps to what you're talking about, where things are just wrong before the grand jury. I understand intuitively the feeling that this is a mistake, but I think that—
I'm not suggesting that at all. I understand that there's substance corrections and there are form corrections. I just was wondering about whether there are any case law that is like this, where the grand jury had no evidence that she was 12 to 16.
Right, and I think, like I said, I think the closest to sort of that type of mistake is probably Souza, but I don't think there is a precise case on point. I just think that when you start looking at mistake or clerical error and saying that that's what this was, that doesn't give you a principled and consistent line that you can apply in future cases. The case law gives you a principled and consistent line that you can apply in cases. There's this, the three-step analysis laid out in Knight and Miranda. One, is it substance or form? Two, if it's form, is there prejudice? And then finally, the additional, does it change the work of the grand jury? But you're not getting to that question about does it change the work of the grand jury if it's an amendment of substance, because we know you can't ever have an amendment of substance. So once you get to that threshold question, and all we're arguing is that this is an amendment of substance, we're not arguing that he was prejudiced, we're not arguing that it changed the work of the grand jury, because we are not arguing that this was an amendment of form.
So this should have been fixed at the grand. Your argument is they changed the substance, and they could have fixed this, but they didn't.
Correct.
Yeah. They could have gone back to the grand jury. We goofed here, or you goofed. I guess the grand jury goofed. I'm not sure how this came up. Do we have any sense of how this happened?
I don't, Your Honor. I mean, I will say that the indictment is strikingly consistent. The caption gives the statutory reference, and then the elements that are laid out are all to small part B. There are cases that are not cited in either briefs about, when the caption doesn't agree with the text, and we can look at just the text. But here the indictment is remarkably consistent, and it lays out an offense under 23A small b. And there just is no case law saying that when you change something like that, when you change the statutory subsection or the form of the offense, even if it's a mistake, there's no case law saying that you're allowed to make that change.
So is this a new trial?
I believe it would be a new trial, Your Honor. I mean, I think they would have to re-indict, frankly. I think they would have to indict, correct?
If we agree to it, it's a reversal and a remand for potential new trial.
Yes, obviously on these offenses. There are other.
I have a follow-up question to that, if I may. My question is, since the problem only relates to the aggravating feature and the rape of a child why is it that the remedy is not up to the Commonwealth to decide whether there would be a retrial or to accept a conviction on the lesser included offense of rape of a child under the age of 16?
So I will say that the vast majority of the cases, when they find a change of substance, simply reversed, don't consider prejudice.
That's not just an aggravated, this is just an aggravating form of a crime.
Correct. And so what I was going to say is, if you look at, I believe it's the Ruiz-Diaz case from the appeals court, they do in that case, without any real explanation, and I think it's the only case that does this, they do just take off the aggravating factor, because what got added there was over age 60. That gets added to one offense. Not a surprise, not a disputed fact, all of that, but an impermissible substantive change because it changes something the Commonwealth has to prove. And in that case, I believe that the remedy is just the lesser offense. That's the only case I know that does that. The rest of them simply reverse without prejudice, and that's certainly what this court has done. But since you're asking the question, I will point you to that case.
Okay.
If you'd like, I can.
And there's no double jeopardy issue here. I'm just
There is no double jeopardy issue here. I mean, he
had trouble following the double jeopardy arguments because the acquittals and convictions got me turned around.
I have a hard time with the double jeopardy test because it is not intuitive in this situation, right? Because functionally, you are tried for that amended offense, but formally, you have been tried for the thing for which you were indicted. So formally,
she's clearly not 12 to 16. So I'm just trying to. So again,
right.
I just want the consequences if we decide in your favor is there's no double jeopardy. I just want to make sure there's no.
Yes, and I say that in the brief.
As Justice Wojciech points out, they lose the minimum mandatory, but they may keep the rape of child conviction.
I'm sorry, can you repeat?
They lose the minimum mandatory, of course, right, if it's reversed.
Do they?
If it's from.
Right, that's
from the 23A to a straight rape of a child.
Right, but then it's
It would go back for resentencing.
I mean, we also have an issue. We also have this lesser included argument on indecent A and B. So I don't know. There's a question, I guess, about what you would take it back to. I think that's probably why most of the cases reverse. But on the double jeopardy test, just briefly, you couldn't charge someone for the same act. And the Commonwealth agrees that the two provisions are mutually exclusive. You couldn't charge someone for the same act under both subsection A and subsection B. You either would have to have a different child or a different year point in time, right? They're mutually exclusive. So as long as they are mutually exclusive, for the purposes of this substance form analysis, that is passing the double jeopardy test, which I agree is confusing. But I do think we pass it, and also I concede that there is not a double jeopardy problem because that's necessary, of course, to my argument. If there is nothing further, I will rest on my briefs.
Thank you. Attorney Hanson.
Thank you. If it pleases the court, Arne Hanson for the Commonwealth of Massachusetts, representing the Plymouth County District Attorney's Office. This change to correct the victim's age on the indictments was a change of form, rather than a change of substance, as the defendant argues. This is a multi-step evaluation, the first of which is, did it change the work of the grand jury? And I think it's undisputed here that it didn't.
Well, no. I mean, that's just not the test. That's the constitutional prong, which we don't get to. I mean, the question is it one of form, and was it essential to the description of the crime? And here, A requires a 5-year age gap and the victim being less than 12. Isn't that right?
Correct.
Okay, and B requires a 10-year age gap and the victim over 12, under 16.
Correct.
Okay, so it is essential to the description of the crime, A versus B.
So that's where I'll get into my second argument right away. It's aggravated rape of a child is one crime, the elements of which are sexual intercourse with a child. The first element is sexual intercourse. Second is child under 16. The third one is the aggravating element. It's the Commonwealth's theory that the aggravating element can be proven under 3 separate theories of the case. The first two deal with the aggravating factor being the age difference. And the court, as you just explained, the younger the child, the smaller the age difference needs to be. And that's A and B. And then the last one is whether or not the individual, the defendant, is a mandated reported. So those are 3 different theories under which the Commonwealth can prove the aggravated element. So the essential elements of the case don't change. It's just a different way of proving the aggravating
Can I
element.
ask you an out? Go on, please. Oh, okay. I got a question.
I'm once again throwing my voice.
Oh, geez. Let's go ahead.
I take it that that argument would sort of rests on the idea that the aggravation is an element or a theory, right? That,
Correct.
and so it doesn't matter which of the 3 versions of it, because aggravation is the element.
Correct.
Okay, so in your view, then if the Commonwealth had wanted to change from B to C, that also would have been an amendment of form and not of substance?
Yes, but
How can that be?
So that comes back to my initial point that it doesn't materially change the work of the grand jury. So if the Commonwealth had also presented to the grand jury that this individual, the defendant, was a mandated reporter, and there was evidence to support that contention, I think the change, because it's supported by the evidence of the grand jury, is a change of form.
See, that runs into the other problem, that the grand jury never heard any evidence the child was fit within B.
Correct. Clearly, the way that it was indicted was a mistake because the evidence supported that she was 8 to 10 when this happened.
So let me take you to another aggravated crime, aggravated assault and battery, all right? So under 13A(b), it says whoever commits an assault and battery, and there are 3 ways to aggravate, just like in this crime, that was aggravated rape of child. One of them is upon another causing substantial bodily injury. Another is a victim who's pregnant, and the defendant has a reason to know. And the third way is with an outstanding restraining order. If you indicted someone, aggravated assault and battery, someone having a restraining order, could you amend it to substantial bodily injury, or would that be an amendment of form or substance?
I would suggest that that would be an amendment of form, provided there was sufficient evidence to support the amendment, provided that evidence was before the grand jury.
So you would advocate, you would ask a trial judge to amend by form a 209A violation to substantial bodily injury.
Correct. I think the parallel that I draw is the reckless endangerment of a child statute that's discussed in Mayotte. So Mayotte, it was the grand jury heard evidence of seriously, or the indictment was based on evidence of serious bodily injury, whereas the evidence at trial was exposure to sexual abuse. Certainly, again, that's the same element within reckless endangerment of a child. Certainly, they require vast differences in proof, but I don't think that changes that the element is either risk of sexual abuse or risk of serious bodily injury.
I'm sorry, and I thought Mayo said that that was a substantive change.
The issue in I don't think Mayotte gets to that. The issue in Mayotte was that the grand jury heard evidence of one, and the indictment was based on serious bodily injury, and at trial, there was no mention of serious bodily injury, and all the evidence supported risk of sexual abuse. And I think Mayotte was overturned because of the grand jury. He was convicted, or she was convicted of something that the grand jury didn't frame or hear.
Any case that actually goes your way that says this kind of change is okay? Because all these go against you. They may go against you for different reasons, but are there anything that supports this kind of differential where?
I think that's why we're here today, because it hasn't been addressed by the case law. I think the closest analogy here is, as Your Honor started with, we're playing age and time. So the Foreman decision, which is a case that I referenced, it's an appeals court case from 2022, I cited in my brief, that talks about aggravated rape of a child, and it talks about the elements, and it says the real thing to consider is the age difference. And it says that's the element, and the age of the victim is the condition that is required to meet that element.
In the jury charge, the judge charged sexual intercourse at a time of the incident, the victim's under the age of 12, the 5-year age difference in unlawful intercourse, right? So the judge gave all these as elements of the crime to the jury.
Yes. So I think the Foreman decision, in my reading of it, seems to suggest that it's the aggravating factor is the age difference, not necessarily the age, and the age is the condition that sets out what gap is required. So it specifically says.
Really? I mean, it's just the difference between a 10 to 12-year-old and a 12 to 16-year-old seems to be one of real substance, isn't it? It's just that's why we have a shorter time frame for. I don't know. It just seems like there's something critical there that's.
I would really, so the Knight case was a murder case where they amended the indictment to specify the date, which wasn't clear. I would suggest to the court that the age of the victim is similar to the date here, where the age of the victim when she is 8 to 10 means this happened on these dates at this time. Therefore, it's clarifying the age of the victim rather than changing anything substantive about the nature of the charges. Because everything before the grand jury, nothing changes. The theory of the case stays exactly the same. The only thing the amendment to the indictment did was correct the victim's age.
Could I ask a question about the other issue? Could you give us your best argument why, with respect to counts 3 to 5, the inconsistencies in the victim's statements that were raised by counsel in cross-examination were not sufficient to warrant a lesser included charge?
Yes, so the victim is 16 years old when she's testifying about this. I think it's important to note that. She talks about the incidents that happened in the office, and she describes in detail how these things transpire. With regards to how she was raped, she says, he spread my legs, he used his fingers.
I understand the evidence was sufficient to prove the charges. The question is whether on cross, the inconsistencies that were raised were sufficient to warrant a lesser included. I don't think that the question, do you agree the question is not whether there was sufficient evidence of penetration?
I thought that's how, I thought the defendants framed it as it's ambiguous, so therefore we don't know and it's in dispute. My argument is that she clearly testified on direct examination that she was penetrated and that the defendant used 1 or 2 fingers to touch.
The question on whether a defendant gets a lesser included instruction is viewing the evidence in the light most favorable to the defendant, is it not?
Yes, so I don't see any form of interpretation that she says I'm touched in between my lips where I pee from. That very clearly constitutes rape.
Agreed, but on cross, she admitted that in earlier interviews, she gave evidence that was more ambiguous. I think the language she used in earlier interviews was that he touched the front part or something like that.
Right, and I think that's a reflection of the fact that you're dealing with when she came out, I believe she was 14 years old and she didn't know the terminology.
The evidence needs to be viewed in the light most favorable to the defendant.
Right, but
I understand that you have a sufficiency non-issue, but
I think the evidence at trial is her testimony at trial, not necessarily what she told investigators 2 years prior. We don't
That
put
came in during trial.
for impeachment purposes. I don't know if it came in substantively.
So how would a defendant ever get a lesser included in this instance, other than by undermining the victim's testimony in a way that specifically went to the nature of the touching?
I think that's how you would have to dispute that.
But he specifically adduced during cross that in an earlier statement, she made vaguer, less clear statements as to whether there was penetration.
Right. I think that goes to the weight and credibility of the evidence, but I don't think it speaks to whether or not it came in. I think the evidence was sufficient.
That was the thing that jumped out to me. Was there, I don't remember this, and you'll know the trial transcript better than I, but was there some limiting instruction, or was there, at the time that it came in, by the Commonwealth saying that this is only coming in for impeachment purposes, or because if not, why doesn't it come in for substantively for all purposes?
I don't recall if there was a limiting instruction given.
Well, wouldn't that be an important thing? Because I agree with you that if it did not come in for its truth, you might have an argument that it only came in for impeachment purposes, and that might not be a reason to give the lesser included. But if there was no cabining of this information by the jury, why wouldn't the defendant be entitled to the lesser included?
So I think the case law is very clear that there must be a sufficient distinction between the set of facts where you consistently find the person guilty of the lesser included versus the original charge. And I don't think we have that here. The fact that, and the case law I cited in my brief, it's not just the mere possibility that the touching didn't constitute rape versus indecent assault and battery. It needs to be very clear, and every single jury must or should be able to find that that there's only evidence of the lesser included and no evidence of the rape here. And I don't think we have that.
Are you suggesting that whenever there's sufficient evidence of the greater crime, you do not charge the lesser crime?
I don't think there was any evidence that it was an indecent assault and battery. She unequivocally testified that she was touched in between her labia over and over.
But this is what happens in every case. There's evidence that potentially, a victim of any kind of crime says X happened, and then an earlier date gave a vaguer statement that makes less clear that X happened, and the defendant is entitled to challenge the credibility of the victim's later clearer statement by pointing to evidence that at an earlier date, the victim did not say that X happened.
Right, and I think that her more vague statement doesn't refute or contradict her testimony at trial.
Isn't this a classic question for the jury as to which offense occurred?
I don't believe so, because it's not in dispute. There was no evidence from anyone else saying the touching actually happened here. The only evidence at the trial was that the touching constituted a rape.
Are you done, Justice Stewart? Let's assume that, and I'm not saying that we will, but let's assume that if we were to disagree with you on this, and we concluded that the judge erred in not giving the requested lesser included offense instruction, what would be that would just result in a reversal of these convictions, is that correct?
Yes.
5 through 8. So we would not reach the first issue that was raised, the one about the amendment.
Yes, logically. Yes.
It would not be necessary.
Yes.
Okay.
Which one's the cart and which one's the horse? Why is that the case? Why isn't the first one the one we would decide and not the second one? I'm not sure I follow that. Seems like
What in your view would be the relief were we to agree with the defendant on the first argument regarding amendment?
It would be a motion for new trial. I agree with defense counsel with regards to that remedy. If there are no further questions, I rest on my brief.